Right now, as you're watching this video, something has already changed about your daily life. And the terrifying part? Most people have absolutely no idea it happened. No breaking news alert, no front page headline, no viral moment that cut through the noise of everything else happening in the world right now. Just a quiet decision, made by 9 people, in a marble building in Washington, D.C., that just rewrote the rules of how power works in America. And once you understand what actually happened, what this ruling actually means, you will never look at your government, your job, your rights, or your future the same way again. Stay with me, because this one is different. Welcome. If you've been following this channel, you know we don't do surface-level coverage. We don't read you headlines and call it a day. We go deeper. We connect the dots that mainstream media either misses or deliberately avoids. And what we're covering today is, without exaggeration, one of the most consequential legal shifts in modern American history. I know that sounds dramatic. I know you've heard things described that way before. But by the time we reach the end of this video, I want you to make that judgment yourself, because the facts here are not subtle. The implications are not small. This affects your workplace. It affects your healthcare. It affects the water you drink, the air you breathe, the safety standards that protect your family. It affects every single federal agency that was ever created to stand between you and unchecked corporate and political power. This is not a left issue or a right issue. This is an American issue, and you deserve to understand it completely. So, let's go back. Let's start at the very beginning. Because to understand what just changed, you need to understand what was already there and why it mattered so much. It's 1984. Ronald Reagan is in the White House. The Cold War is still very much alive, and somewhere in Washington, a legal battle is quietly moving through the court system that almost nobody is paying attention to. The case involves the Chevron Corporation, yes, the oil company, and a group of fishing companies who are challenging a federal regulation about how many government monitors had to be placed on their boats. It sounds small. It sounds technical. It sounds like exactly the kind of legal dispute that you'd scroll past without a second thought. But what came out of that case would shape the next 4 decades of American government in ways that most citizens never fully grasped. The Supreme Court, in a unanimous decision, established what became known as the Chevron Doctrine. And here is what it said in plain English. When Congress passes a law, that law sometimes has gaps, ambiguities, areas where the language isn't perfectly clear. And when those gaps exist, the Chevron Doctrine said, the federal agency responsible for enforcing that law gets to fill in those gaps. The agency gets to decide what the ambiguous language means, and courts should defer to that interpretation as long as it's reasonable. That's it. That's the rule. Now let's think about what that actually meant in practice. The Environmental Protection Agency, the EPA, interprets environmental laws and sets pollution standards. The Food and Drug Administration interprets food safety laws and decides what chemicals are allowed in your food. The Occupational Safety and Health Administration, OSHA, interprets workplace safety laws and decides what protections your employer is legally required to give you. For 40 years, these agencies had the authority to adapt their interpretations as new science emerged. As new technologies arrived, as new threats to public health appeared that Congress couldn't have anticipated when it first wrote the original legislation. And for 40 years, courts generally respected that authority. It wasn't perfect. Nothing in government ever is. But the Chevron Doctrine represented a fundamental agreement between the branches of government, an agreement that said, look, these agencies are staffed by experts, scientists, economists, public health specialists, people who have spent their careers understanding these incredibly complex fields. Let them make the technical calls. That agreement just ended. The case that changed everything is called Loper Bright Enterprises versus Raimondo. And just like Chevron, it started small. It started with fishing boats. Loper Bright Enterprises is a family-owned commercial fishing operation based in New Jersey. For generations, this family has fished the waters off the Atlantic coast. And like many small fishing businesses, they operate on thin margins. The difference between a profitable season and a devastating one can come down to a few $1,000s. So, when the National Marine Fisheries Service, a federal agency, issued a rule requiring certain fishing vessels to carry federal monitors on board and then said those fishing companies would have to pay for those monitors themselves, Loper Bright pushed back. Now, the cost wasn't astronomical in the grand scheme of federal regulation. We're talking about roughly $700 a day when a monitor was required. But for a small family fishing business, that number hits differently. That's the difference between operating and shutting down. So they sued, they challenged the rule, and their legal team made a very specific argument. They said Congress never explicitly authorized the National Marine Fisheries Service to make fishing companies pay for these monitors. The agency filled in a gap in the law on its own. And under the Chevron doctrine, courts had been deferring to that kind of agency interpretation for decades. But here's where the story takes a turn that nobody, and I mean nobody outside of a very small circle of legal scholars and conservative legal strategists, fully anticipated. The Supreme Court didn't just rule in favor of Loper Bright on the narrow question of who pays for the monitors. They went further, much further. In a 6-3 decision written by Chief Justice John Roberts, the Supreme Court did something that legal experts are calling a seismic shift in American constitutional law. They overruled Chevron entirely, not modified it, not narrowed it, overruled it. Gone. 40 years of legal precedent, wiped away. And now, let me tell you what that actually means. Because this is where the story gets serious. Chief Justice Roberts wrote that courts, not agencies, must decide what federal statutes mean, that it is emphatically the province and duty of the judicial department to say what the law is. And on its surface, that sounds almost reasonable, right? The judiciary interprets laws. That's civics class. That's what we learned in school. But here's what that principle means in practice, and this is the part that should stop you cold. When the EPA tries to set new limits on carbon emissions and a corporation challenges that rule in court, a judge, not a climate scientist, not an environmental chemist, not a public health expert, a judge gets to decide whether the EPA's interpretation of the Clean Air Act is correct. When the FDA tries to regulate a new drug or food additive and a pharmaceutical company disagrees with that regulation, a judge gets to substitute their reading of the Food, Drug, and Cosmetic Act for the FDA's reading. When OSHA tries to update workplace safety standards for a new industrial hazard and a manufacturing company challenges it, a judge gets to override the interpretation of people who have spent decades studying workplace injuries and occupational disease. The expertise that the agency has accumulated over years, over decades, it no longer gets deference. It no longer gets the presumption of correctness. The judge decides, and if the judge reads the statute differently than the agency did, the agency loses, the regulation falls, the protection disappears. But wait, because what happened next made all of this even more complicated. On the exact same day that the Supreme Court handed down the Loper Bright decision, they handed down another ruling in a case called Corner Post Incorporated versus Board of Governors of the Federal Reserve System, and this ruling extended the deadline for challenging federal regulations in court. Previously, there was a 6-year statute of limitations on challenging agency rules. After 6 years, a regulation was generally considered settled law. Corporations, industry groups, whoever didn't like a particular rule had 6 years to mount a legal challenge, and after that window closed, the rule was locked in. Corner Post blew that window wide open. The court ruled that the 6-year clock doesn't start running until a party is actually affected by a regulation. So if a new business is formed today and it decides it doesn't like a regulation that was put in place in 1995, it can challenge that regulation now. Today, as if those 30 years never happened. Think about what that means. Think about what that actually opens up. Regulations protecting your pension. Regulations governing how banks handle your mortgage. Environmental rules protecting the drinking water in your city. Worker safety standards that have been on the books since before some of us were born. All of them suddenly vulnerable. all of them potentially back on the table, in courts that, thanks to Loper Bright, no longer have to defer to the agencies that wrote them. Now I need you to stop for a moment. I need you to really let this land. Think about the last time you drank a glass of tap water and didn't think twice about whether it was safe. Think about the last time you bought a bottle of medication and trusted that what it said on the label was actually what was inside. Think about the last time you went to work and assumed, without even consciously thinking about it, that your employer had a legal obligation not to expose you to something that would damage your lungs, your brain, your body. That trust, that assumption of safety, that invisible net of protection that you have been living inside of your entire life, it was built regulation by regulation, rule by rule, agency decision by agency decision, over decades, by experts fighting against industries that had every financial incentive to resist those protections. And the legal architecture that held all of those regulations in place just got fundamentally restructured. I'm not telling you every regulation is going to collapse tomorrow. I'm not telling you this is the end of the EPA or the FDA, but I am telling you that the legal landscape in which those agencies operate has changed dramatically. And the people who understand that best, the corporate lawyers, the industry lobbyists, the legal strategists at think tanks funded by people who have spent decades trying to roll back federal regulations, they already know it. Within days of the Loper Bright ruling, legal analysts started cataloging the regulations that are now most vulnerable, and the list is long, and it hits close to home. Clean water protections under the Clean Water Act, air quality standards under the Clean Air Act, net neutrality rules that govern how your internet service provider can treat your data, financial regulations put in place after the 2008 financial crisis to protect ordinary Americans from predatory banking practices, rules governing how student loans are administered, rules protecting gig workers and independent contractors from exploitation. All of it. All of it is now more legally exposed than it was the day before this ruling came down. And here's where the story gets personal. Here's where I need you to think about your own life. Maybe you're a teacher, and you've seen what happens when lead contamination gets into the water supply at a school. You know what it does to kids' developing brains. You've watched children in Flint, Michigan pay the price for a failure of regulatory protection. And now you're watching the agencies responsible for preventing the next Flint get legally weakened. Maybe you're a small business owner, and you've been competing against larger companies that would love nothing more than a regulatory rollback that lets them cut corners you can't afford to cut. The businesses that benefit from deregulation are rarely the small family operations like Loper Bright. They're the massive corporations with legal teams large enough to exploit every new opening in the system. Maybe you're a parent, and you look at the world your kids are going to inherit, the climate instability, the pollution, the health challenges, and you understand that the agencies built to manage those crises just had their hands partially tied behind their backs. Maybe you're a worker, and you know what it's like to be in a job where the only thing standing between you and a dangerous working condition is a federal rule that your employer can't legally ignore. And now that rule, and hundreds like it, are more legally vulnerable than they've ever been in your lifetime. This isn't abstract. This isn't constitutional theory. This lands in real communities, in real kitchens, in real conversations between real people trying to protect their families. And there's one more dimension to this that most of the coverage has completely missed. Something deeper. Something that gets at the actual architecture of what just happened and why it happened now. The Chevron doctrine was not overruled by accident. It was not overruled because 9 justices independently read the law and arrived at this conclusion on a Tuesday afternoon. This outcome was the product of a decades-long, extraordinarily well-funded, meticulously organized legal strategy. And understanding that strategy is the only way to truly understand what just changed and why it matters beyond this single ruling. Go back to the 1970s. The modern regulatory state is being built. The EPA is created in 1970, OSHA in 1971, the Consumer Product Safety Commission in 1972. These agencies are staffed, funded, and empowered to regulate industries in the public interest. And certain industries, fossil fuel companies, chemical manufacturers, financial institutions, begin funding a counter strategy. Not a political strategy, primarily, a legal strategy. A systematic effort to reshape how courts interpret the relationship between federal agencies and the law. Organizations like the Federalist Society begin training a generation of lawyers and judges in a philosophy of statutory interpretation that is deeply skeptical of administrative agency power. Billions of dollars flow into legal advocacy groups, into law school programs, into judicial nomination strategies aimed at placing judges with this philosophy on federal courts at every level. The goal, stated openly in some circles and more quietly in others, was to use the judiciary, the one branch of government with lifetime appointments and the last word on legal interpretation, to constrain the regulatory state in ways that couldn't be achieved through the ordinary political process. And after 50 years of patient, funded, organized effort, the goal was achieved. The 6 justices who voted to overturn Chevron were all either nominated by Republican presidents or had significant connections to the legal movement that targeted Chevron specifically. This was not a surprise outcome to the people who engineered the legal strategy that produced it. This was the plan reaching its conclusion. And now those same networks are already identifying the next targets, the next regulations to challenge, the next legal arguments to advance in a post-Chevron judicial landscape that is structurally more favorable to their goals than any legal environment in the last 40 years. This is not cynicism. This is simply what happened, documented, recorded, and available for anyone who looks. The question now is what comes next. And the answer to that question depends almost entirely on whether ordinary Americans understand what just changed and what it actually means for their lives. So here's where we are. The Chevron doctrine is gone. 40 years of legal architecture that supported the regulatory state has been dismantled in a single ruling. Courts now have the authority and the mandate to substitute their own reading of federal statutes for the reading of the expert agencies that enforce those statutes. A parallel ruling has opened the door to challenges against regulations that have been settled law for decades. Rules you never thought twice about are now legally exposed. And a decades-long legal movement, funded by interests that have every incentive to weaken the regulatory protections that stand between their bottom line and the public interest, has now achieved the judicial environment it spent 50 years trying to build. I am not telling you what to believe about regulation. I am not telling you that every agency rule is just and necessary and perfectly crafted. Government is imperfect. Agencies make mistakes. Overreach happens. Reasonable people can disagree about where the lines should be drawn. But I am telling you this. The system that existed before this ruling had checks built into it. Courts still reviewed agency decisions. Agencies still had to demonstrate their reasoning. Congress still had the power to override agency interpretations through legislation. The balance wasn't perfect, but it existed. What exists now is a fundamentally different balance, one in which the most powerful legal tool for challenging the protections that govern your air, your water, your food, your workplace, and your financial life has been handed to entities with the resources to use it aggressively and the incentive to use it immediately. And most Americans don't know it happened. The news cycle moved on. The algorithm found something more immediately emotional to serve you. The complexity of administrative law made it easy to gloss over. And the people who benefit most from your confusion were very happy to let the story fade. Don't let it fade. Share this. Talk about it. Ask your representatives what they're doing about it. Understand that this is not a story about legal abstraction. It is a story about the invisible systems that protect your daily life, and about what happens when those systems are quietly, methodically dismantled by people who understood exactly what they were doing while everyone else was looking the other way. The decision has been made, the precedent has been set, and what happens next is up to you.